openings and
Yes,
final closing?
yes.
Okay. All right, do we have all jurors here?
Yes, Judge.
Okay. All right, states present, defendants are present, defense counsel's present. Anything else before we begin?
I was hoping to waive my opening until the beginning of my evidence, partially due to a witness.
That's fine.
Is that all right? And then I have
I don't have an objection. State, you have any objection?
I think I'm sorry. I'm going to waive my opening until the beginning of my presentation of evidence.
Yeah, I think if I can step. I'm
Jessica
sorry.
Treatise on behalf of Isaiah Chance.
No objection.
Judge, with the court's permission, if I could, Mr. Boldis here, if I could step out at around 1:45, I have to run down a different judge.
Yeah, that's fine.
Okay.
Okay. Other than that, are we ready to go? Okay, I assume you are.
Judge, I do have some matters I want to address to the court as far as discovery in this case, but we can do that at the end of the day, court issues.
Okay,
And I wanted to talk to you about scheduling.
yes,
As far as availability, I have an expert that I've retained on Friday to deal with the late discovery by Mr. Davion Murphy, but his availability is limited.
okay.
That's one thing.
Well, what does that mean? When's he available?
Well, first he'll need to appear by Zoom.
Okay,
He does a lot of expert work. He's also a practicing radiologist, diagnostic radiologist. The state's forensic psychiatrist that we've hired did conduct the evaluation Saturday and completed both of them, of Mr. Chance and Mr. Murphy, Davion Murphy. I would like to have her watch the testimony of Dr. Hardig in the Chance case, and Dr. Eisenstein in the Gathright case, and Dr. Collins in the Rashad Murphy case by Zoom if possible. And so I wanted to make sure the court was okay with that. I'm sorry. Did I say Gathright? I'm sorry, I apologize.
okay.
That was, yeah.
I don't have a problem with that, but you may have to get with the tech people here and figure out how to do that.
The alternative is to have her watch the live stream that's occurring right now. So we may just do that but I just want to make sure, I know that we invoke the rule that this is an expert witness.
Yeah, so, I mean, I don't have an objection per se to having your expert watch the live stream of just those expert witnesses. I don't have an objection to it, some of the defendants do. So, and if they do, then you'd have to figure out some way to, via Zoom, to put some type of camera on the witness stand.
Okay. All right. We'll figure it out, Judge. Thank you.
Okay? Okay. Yes.
Sorry.
Sure.
I think I misspoke when I said wave. I'm not waving my own. I just said reserve.
Yes, that's fine.
Okay.
I understood what you were saying. Okay, all right. Anything further?
There you are. Not from the state.
Okay. All right, very good. Let's bring in our jury.
Thank you.
All rise. All jurors are in, Judge.
Okay, very good. Welcome back. Hope you all enjoyed your weekend. While we were on the weekend recess, did anybody watch, read, listen to the news accounts or social media posts related to this case? Talk to anybody about this case or do any independent investigation on this case? No one's raising their hand. I'll take that as a no. Okay, I have just a quick introduction as far as the jury instructions. Members of the jury, you have found each of the defendants guilty of one count of first-degree murder. The only issue before you in this phase of the trial is to determine the appropriate penalty. The penalty for the crime of first-degree murder is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say, however, during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendants may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you heard during the guilt phase of the trial, is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors outweigh any mitigating circumstances the defendants proved by the greater weight of the evidence. Finally, you will decide whether each defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are: as to defendant Rashad Murphy, first aggravating factor, the defendant was contemporaneously convicted of a felony involving use or threat of violence to a person. The second one, the defendant knowingly created a great risk of death to many persons. The third one, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And 4, the capital felony was committed by a criminal gang member. As to defendant Isaiah Chance, as to first-degree murder, the first aggravating factor is, as alleged by the state, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The second aggravating factor, the capital felony was committed by a criminal gang member. As to defendant Sean Gathright for first-degree murder, the first aggravating factor is the defendant was contemporaneously convicted of a felony involving the use or threat of violence to a person. The second aggravating factor, the defendant knowingly created a great risk of death or harm to many persons. 3, the capital felony was a homicide and was committed in a cold, calculated, and premeditated murder manner without any pretense of moral or legal justification. As to defendant Davion Murphy for first-degree murder, the state alleges the following aggravating factors. 1, the defendant was contemporaneously convicted of a felony involving the use or threat of violence to a person.
Yeah, main stage,
Second,
right?
the defendant knowingly
They are
created
cooked.
a great risk of death to many persons. Third, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And 4, the capital felony was committed by a criminal gang member. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's
I was
death.
good with you, Dre. Too
However,
much.
victim impact
Shout out
evidence
to you,
must
homie.
not be considered by you as
How your channel
itself
get to
an
it?
aggravating factor.
That's fucked
A
up.
mitigating circumstance can be anything that might indicate the death penalty is not appropriate for a defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of a defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, I will give you instructions on the law.
Oh yeah,
The
that's
attorneys
fucked
will
up.
then have the opportunity to make their closing arguments.
Still in
Following
AZ.
the closing
Getting
arguments
hot out
by
here,
the
man.
attorneys, I will then conclude with final
Sure.
instructions to you. After the final instructions are given, you will begin your deliberations. Again, you should not form
Yeah, I
any
can't believe,
definite or fixed opinion until you have heard
Old
all
boy
of the
started
evidence,
crying after
argument of the
they
lawyers,
they
and
found
the
them
instructions
guilty.
on the law. Until that
Like,
time, you
nigga,
should
you
not
didn't see all
discuss
that
the
shit
case
they had
amongst
y'all on camera?
yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court may take recesses and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone or permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell that person at once.
Crying and they
Or the
rubbing
jury
his
and ask
shoulders
that
and
person
shit
to
like,
stop.
oh,
If that person persists,
you all
let
right.
that person at once and
Nigga,
immediately
you just
report
shot
the
100
matter to the bailiff
times
who will
on
advise you.
camera.
All cell phones,
Tracked you
computers,
all the way to the
tablets, or other
murder.
types of
All
electronic
the way back
devices must
home.
be turned off while you
Come
are
on,
in the
nigga.
courtroom.
What you thought you was going
Turned
to do?
off means that the
You better
phone
just
or
hope
other
you don't get
electronic
the death
device is
penalty.
actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out about any
Mr.
information
Christopher,
about
shout
the
out
case
to you, young
or
man.
communicate with anyone about the case or the people involved in the case. Again, do not take photographs, video
These young
recordings,
niggas
or
threw their
audio
life away.
recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number has been provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendants, the attorneys, and myself. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors, again, must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use your phones, computers, or other electronic devices to communicate about this case. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog.
Hey Dre, how do I
As we
go in
discussed
the
previously, what are the
chat and
reasons
give
for
you a
these
ring,
rules?
Tony?
These rules are
I'm
imposed
trying to do
because
that, but I
jurors
can't
must
figure it
decide
out.
the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and to challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. Again, in every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence. And the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor would a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary. All right, State, do you wish to make an opening statement at this time? Yes.
Members of the jury, last week, all of you unanimously found all four defendants guilty beyond all reasonable doubt of first premeditated murder. We are now in penalty phase, and the state of Florida is asking each of you to recommend the most severe sentence that our state allows, and that is the death penalty for each of the defendants in this case based on the aggravating factors that exist. You have heard that not all murders qualify as first-degree murder under our law. And as you were instructed last week in the jury instructions, that not all murders are first-degree murders. You've heard about second-degree murder and manslaughter, both of which do not warrant and cannot be punished by the death penalty. And now you have heard, as the judge has instructed you this morning, that not all first-degree murders warrant the death penalty. The law in the state of Florida requires that only first-degree murders where aggravation has been proven beyond a reasonable doubt can warrant the death penalty. And the law requires at least one aggravating factor to justify and warrant the death penalty. In this case, you have heard that all of the defendants in this case have more than one. Rashad Murphy has 4 aggravating factors. Davion Murphy has 4 aggravating factors. Sean Gathright has 2 aggravating factors. And Isaiah Chance Sean Gathright has 3 aggravating factors, and Isaiah Chance has 2 aggravating factors. All of the defendants meet the requirements that warrant the aggravation, which is required, that warrant the most severe sentence in the state of Florida. Last week, it was the state of Florida's burden to prove the elements of the facts of the case, the elements of first-degree murder, and all of the other charges beyond and to the exclusion of any reasonable doubt. This phase of the trial, we will prove the aggravation beyond all reasonable doubt. All of these aggravating factors have already been proven beyond a reasonable doubt by the evidence that you have already heard in the guilt phase. One of the aggravating factors not only has been proven by the evidence, but it is inherent in your verdict and already found by all of you to have been proven beyond a reasonable doubt. I'm going to go through each of these aggravating factors that apply to each of the defendants. Starting with Rashad Murphy, that first aggravating factor, the defendant was contemporaneously convicted of another felony involving the threat of violence or the use of violence against another person. When you found Rashad Murphy guilty of 3 counts of attempted second-degree murder for the attempted murder of Gino Norris and Xavier Edwards and Camilla Bentley, in your verdict, you found and convicted him of another violent crime against another victim in this case. That is one of his aggravating factors. That is what aggravates this crime beyond a first-degree homicide. 3 additional victims of violent crime. Those count as one aggravating factor against Rashad Murphy. And it is inherently decided by all of you when you found and convicted him of those 3 counts of attempted second-degree murder. The defendant knowingly created a great risk of death to many persons. Again, based on the facts and the evidence that has already been presented to you and proven to you in the guilt phase, Rashad Murphy, there is no doubt that he was one of the shooters. And the facts in this case shows that he created a great risk of death to many people. Again, your convictions for the 3 counts of attempted murder, second-degree murder of those 3 other victims show that there were other victims that were in losing their lives. You have him firing into a vehicle of the victim in this case, where there were 2 other people in his car with him who did get shot. You also have a vehicle behind him. His girlfriend, Charles Jones' girlfriend, she was parked behind him with 2 other passengers in her car. They were also exposed to death. He created a risk of death to many people. And let's not forget Camilla Bentley, who was in a car that was next to the victim, Charles Jones, when he was killed. Her car was fired upon, and she also was shot during the course of them trying to kill Charles Jones. But the risk to many people goes beyond all 3 of those additional victims that were shot and killed in this case. They fired on that victim in a hotel parking lot that was filled with guests, filled with cars. They knowingly decided to kill Charles Jones at that location, creating a risk of death to many people beyond the one that they killed, the 3 others that they shot, but to the guests and the employees of that hotel. And you heard directly from 2 other victims in this case, Audra Agramonte, who was in one of those hotel rooms where she was moving in her daughter to the University of South Florida, where her and her husband and her daughter's boyfriend all had to go down to the ground because bullets flew into their hotel room. You heard from Pablo Gabor how him and his family were in their hotel room and how bullets came into his hotel room. It is beyond all reasonable doubt that we have proven this aggravating factor as well against Rashad Murphy and against all of the shooters in this case. The defendant knowingly created a great risk of death to many persons. The third aggravator, Rashad Murphy, cold, calculated, and premeditated. Cold means that the murder was the product of calm and cool reflection. Calculated, having a careful plan or prearranged design. The period of time for premeditation must be long enough to allow for reflection. For this aggravating circumstance, the premeditation must be heightened. There is a substantial period of reflection that is required for this aggravator. And again, you have heard the facts of this case that show how cold and calculated this plan was to kill the victim in this case. And the final aggravating circumstance that has been proven against Rashad Murphy is that the capital felony was committed by a criminal gang member. You have already made a finding beyond all reasonable doubt that the defendant was a gang member or associate in a criminal gang, and that the defendant committed the crime for the purpose of benefiting, promoting, or furthering the interests of that criminal gang. How the aggravating factor is different from the enhancement that you made during the guilt phase of this trial is that the enhancement allows for either a criminal gang member or a criminal associate. The aggravator only applies if the defendant is a criminal gang member. And again, the facts in this case proven beyond all reasonable doubt is that Rashad Murphy was indeed a criminal gang member. And the distinction between a member and an associate is the number of criteria that they meet. An associate only has to have 1. A criminal gang member has to have 2 criteria or meet the criteria for the criminal gang statute to be recognized under the law as a criminal gang member. And for Rashad Murphy, there were 3 different criteria that he fell under. He definitely was proven to be a criminal gang member pursuant to the criminal gang statute. Davian Murphy has all of the same aggravators that we have just gone through and went over for Rashad Murphy, that he was contemporaneously convicted of another felony involving the use of violence to another person. And again, you have already convicted him beyond and to the exclusion of all reasonable doubt of 3 counts of attempted second-degree murder. The defendant, who was a shooter in this case, knowingly created a great risk of death to many persons, cold, calculated, and premeditated, and that he was a criminal gang member when he committed this capital felony. And again, he had met three of the criteria of being a criminal gang member. There is no reasonable doubt that he was a criminal gang member and that he committed these crimes to benefit the interests of a criminal gang. Sean Gathright, there are three aggravating factors: that he was convicted of a felony involving the use or threat of violence to another person. Again, he was a shooter in this case, and he was convicted of 3 counts of attempted second-degree murder. The defendant knowingly created a great risk of death to many persons. Again, as a shooter, he exposed not just the victim to death, but all 3 of those other victims who were shot and could have died, as well as all of the other individuals in the victim's party that were in those vehicles and in the line of gunfire. And those victims that were in the hotels that also were in the line of gunfire. The last defendant, Isaiah Chance, also has the aggravating factor of cold, calculated, and premeditated, and that the capital felony was committed by a criminal gang member. Again, he had 4 different criteria that he met to prove that he was a criminal gang member. We anticipate and expect that you will hear from each of the defendants and that they will present to you evidence of mitigation. And just as Judge Sisko has instructed you this morning, you will independently look at each of the defendants separately and evaluate the aggravation and the mitigation individually for each defendant, and then make a decision as to what the appropriate sentence will be. Again, you will be instructed that the law neither compels you or requires you to recommend a death sentence. However, the law does require that you as a juror determine the weight of the aggravators and the mitigation for each defendant in this case. You decide how much weight to give the aggravators in this case. You decide how much weight you are going to give the mitigation that each defendant presents to you. And they have to prove their mitigation by the greater weight of the evidence. And each of you will decide whether or not they have met that burden and how much mitigation you are going to, how much weight you are going to give their mitigation. And again, this is not a mathematical equation. It is about the quality of evidence. The law requires a death sentence is only warranted in a first-degree murder case where there is at least one aggravating factor that has been proven beyond a reasonable doubt. There is no more difficult decision as a juror in a criminal case than a juror will ever have to make than to determine whether or not a death sentence is warranted. But in this case, as to each defendant, there is more than one aggravating circumstance that has been proven beyond any reasonable doubt. And all of the defendants, all of them, have the aggravating factor of cold, calculated, and premeditation. This is a first-degree premeditated murder that is heightened. This is a senseless killing. I submit to you the facts that you heard during the guilt phase show how the victim was executed with cold, calculated precision. This was heightened premeditation beyond what is required for premeditation. the evidence showed and proved that there was a significant time of reflection, thinking about how to commit first degree premeditation. They thought about it, and the evidence shows how much they planned all of the details, how they carefully planned all of the details. They made travel arrangements. They acquired weapons in advance. They acquired ammunition in advance. They planned and decided how they would look and what they would wear so that they could get away with murder. They acquired masks, dark clothing. They discussed how they would communicate with one another, who would not be using their devices, carefully planning how and where and who would do what. Those are strong evidence beyond all reasonable doubt of how aggravating this homicide is and what separates it from any other first degree homicide. And after you have weighed all of the aggravation and the mitigation, we will ask you individually to recommend the death penalty against each and every one of the defendants in this case.
All right, Mr. Hernandez, do you make an opening statement at this time? Yes.
Council. Good afternoon, ladies and gentlemen. I want to begin by thanking you for your service. We've been here 5 weeks, and your attention to this matter has been exemplary. And certainly in the course of this penalty phase, we're not disputing your verdict at this time. We respect it, and we're moving on. This is my opportunity, as well as the other attorneys, to show you reasons why a life recommendation is appropriate in this case, specifically to my client, Rashad Murphy. During jury selection, which seems like a long, long time ago, and it's the reason that you're here on this jury panel, is that you all committed to keeping an open mind as charged. And of course, here we are. As you've been reminded, and will be reminded, I'm sure a lot more during the course of this week, your recommendation carries great weight. As I think I indicated during jury selection, it's a term that kind of bothers me because it suggests that you're simply making a recommendation and then it becomes somebody else's decision. And the truth is that legally, your vote is something that does carry great weight, and the court has to give it great attention. And it's not often when a court disagrees and rules differently. As you know, aggravating factors have to be proven by the same standard that we had during first phase, proven beyond a reasonable doubt, and at least one aggravating factor is required. On the other hand, mitigating circumstances can be proven by the greater weight of the evidence. We talked about it in jury selection, that it basically is just tipping the scales. If you believe that more likely than not, some mitigating circumstances presented to you, circumstances, and compare it to whatever else is presented in the form of mitigation as well as aggravation. And as you've been told, it is a weighing process, but ultimately you decide what you personally believe is the appropriate vote or decision. And I believe the evidence will show that the appropriate vote is a vote for life without the possibility of parole. And I want to emphasize that when I say life without the possibility of parole, that means that my client, Mr. Murphy, will die in prison. It's just a matter of whether or not there's no chance of early release or anything of that nature. It's life without the possibility of parole. Now, with respect to Mr. Murphy, my client, there will be basically two parts to the presentation. You will hear from witnesses, family members, or friends that who know the defendant well and can provide information about the defendant's background, childhood, the environment, the neighborhood, and the community that he grew up in. But you will also hear testimony, probably Wednesday is my best guess, from a mental expert, Dr. Michael Collins, who is a forensic neuropsychologist. He did a full psychological of Mr. Murphy while at the jail before, obviously, the trial began. He reviewed multiple reports and interviewed the defendant, spent hours with the defendant, gaining extensive information about the defendant as a person and his history. And of course, he conducted a series of psychological tests, allowing him to furnish a comprehensive analysis of the defendant's mental condition and how it relates to the penalty phase, how it relates to the vote that you're going to be asked to provide. There's much more detail to follow, but basically the diagnosis in a nutshell is post-traumatic stress disorder, PTSD. It's a mental health condition triggered by experiencing or witnessing terrifying events, causing symptoms like flashbacks, nightmares, severe anxiety, and uncontrollable thoughts about the trauma. It disrupts daily life, making work, relationships, and sleep difficult. Treatment includes psychotherapy and medication. You will see that Rashad Murphy had an extremely difficult childhood, growing up in a crime-ridden, violent environment. He experienced or witnessed overwhelming, life-threatening, or traumatic events, all causes of post-traumatic stress disorder. The following mitigating circumstances that the defense intends to prove by the greater weight of the evidence is as follows. Number one, the defendant was only 30 years old when the homicide occurred. Number two, the capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. Number three, the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. Number four, the defendant has a history of physical, sexual, or emotional abuse as a child consistent with childhood post-traumatic stress disorder. Number five, the defendant has maintained a loving relationship with family and friends while incarcerated. Number six, the defendant has displayed appropriate behavior and the ability to follow rules while incarcerated. And in fact, you'll see that he in fact received his GED while incarcerated, and took 15 hours of parenting classes. Number seven, the defendant has developed religious and spiritual awareness while incarcerated. Number eight, the defendant helped raise his younger siblings, working jobs, including working jobs at a young age to provide financial support. Number nine, the defendant loves his children and has been a very good father to them. Number 10, the defendant, as a minor, was removed from his primary home and placed into foster care due to negligent and abusive situations in the primary home. And then finally, number 11, defendant has no prior felony convictions. Now, ladies and gentlemen, I saved number 11 for last on purpose because I believe the evidence is going to show that despite the terrible environment that the defendant grew up in, despite these scars, despite the mental issues he lives with on a daily basis, Rashad Murphy has no prior felony convictions. He was 30 years old at the time of the offense, and he has no prior felony convictions. Not one. Not one. Before you vote, I will ask you to compare that fact, not disputed by the state, that the defendant has no prior felony convictions. I will ask you to compare that to a career offender. I will ask you to compare that fact to someone who has a prior record of similar crimes or violent behavior. I will ask you to compare that fact to the state's argument that the attempted murders serve as an aggravating factor despite being one incident. They were all one incident. It was all one contemporaneous event. And I would ask you to compare that fact to the state's argument that an aggravating factor is that the defendant was a criminal gang member. That proposed aggravating factor by the state, compare it to the fact that the defendant has no.
What's the legal basis?
Argument.
Overall, go ahead.
I would, thank you, Your Honor. I would ask you just simply to make that comparison. I believe, ladies and gentlemen, that the mitigating circumstances will outweigh any aggravating factors that might be presented by the state. But in any event, I believe that the mitigating circumstances will show that a life recommendation is warranted. Thank you.
Okay, very good. Ms. Finkelstein?
Good afternoon. Members of the jury, we first want to thank you for your attention and your thoughtful, thorough consideration in the case so far. We all understand the significance of what you have done and what we're asking you to do. I ask that you continue to listen intently and give this second phase of the trial the same attention that you did the first. We saw you taking notes, listening. We know it's been a long several weeks. Nothing in this phase is intended to diminish the seriousness of the charge or what happened in this case. The pain caused, the value of the life lost. Mitigation and mitigating factors are not an excuse. They're an explanation. They tell a story. This is the part of the trial about Sean Gathright, about the person. And this is not about asking if Mr. Gathright is guilty or not guilty. You have already found that with your verdict, and we respect your verdict. This phase asks a different question. And it's not even whether or not Mr. Gathright should be held accountable. He will be. The question now is, should this very young man be permanently sentenced to death? Or does he have a life worth saving? During this phase, you're going to hear about who Mr. Gathright was before the events that you've heard about in this trial. You're going to hear about a childhood that was marked with some instability due to being in a military family, repeated separations from his parents, some abuse by his father, loss, absence of steady guidance during some of his most formative years. You're going to hear that Mr. Gathright was barely 18 years old at the time of this crime, the youngest. At an age where society, common sense, and the law itself recognize that judgment, impulse control, and decision-making are still developing. He's still maturing. As he sits here today, he's only 20 years old. The evidence is going to show you that Sean Gathright is not a man beyond hope or beyond redemption, but a very young human being, still capable of growth, maturity, accountability, remorse, and change. You're going to hear some other really important things, and you're going to hear from people that know him best. You're going to hear from several of Mr. Gathwright's family, friend, guidance counselor, and they're going to tell you about a loving, respectful, nonviolent young man that they knew. A smart student, a good student who loved his family, was a good uncle, helped others, did mission trips, fed the homeless, worked hard, built a business, and showed great potential for a meaningful future. You're also going to hear from an expert who's going to tell you that even in prison, Mr. Gathright can live a constructive life where he can continue to mature and positively affect others, including his family and friends who he maintains a relationship with, but also other inmates. And he can be held accountable without ending his life. At the end of this phase, I will get back up here and I'm going to ask you to consider all of the circumstances that will be presented in that evidence. And I'll give you a long list of things that I think have been shown at that time. I'm going to ask you to not define Mr. Gathright solely by the worst thing that he's done at 18 years old, but to recognize that he still has meaning. His life still has value. Death is never required. And Sean Gathright has a life worth saving. Thank you.
All right, Ms. Toomey, do you wish to make an opening statement at this time? Yep.
Good afternoon, everyone. I just want to start off by thanking you for the time that you have taken away from your family, your friends, your job, and sacrifice what you've sacrificed in order to do this for all of us. Unfortunately, there's no one in this courtroom that can undo what happened. No verdict, no sentence, no punishment will bring Charles Jones back. His family, his friends, are experiencing and did experience real pain. We acknowledge that and we fully accept and respect your verdict of guilt. But by virtue of your verdict, Davion Murphy's fate has been sealed. He will die in Florida State Prison. That is for sure. That's a fact. He's going to die one way or another. The only question that remains that you have to answer in this phase, in the second phase, is whether Davion Murphy dies when a higher power says so, or when the state of Florida decides that it should be done. It's the only question left. As I said, his fate has been sealed. He will live every minute of every day, of every month, of every year, incarcerated in prison for the rest of his life. There is no parole in the state of Florida. There's no good behavior. There's no game time. And Mr. Davion Murphy's life is worth saving. An individual should not be judged by one tragic, terrific event. You have to consider the whole person. And that's what mitigation is. I expect that you're going to hear testimony from several doctors. You're going to hear from Dr. Eisenstein. He's a neuropsychologist. And he's going to tell you about Davion's childhood, his intellectual struggles in school, how he has a very low IQ. He was in ESE classes. He was in an IEP program while he was in school. But one of the most defining things in Davion Murphy's life was when Davion Murphy was just a mere 12 years old. And his father got arrested and charged with murder. His father and his uncle were charged with the same murder. And as you all sit here, as we all sit here, as Davion Murphy sits here, his father is doing life in prison. That happened when he was 12. And his uncle is also incarcerated. As you know, as you've heard in the first phase of this trial, Mr. Murphy grew up in Jacksonville. And at a young age, 12, 13, 14, 15, violence and death were the norm in those communities, in that community that he lived with. It became normalized. I also believe that you will hear from Dr. Eisenstein and tell you that he grew up without a father figure, obviously, no stable environment, no financial stability whatsoever in his life. You're also going to hear that Davion himself was shot, that he's had multiple close family members that have been shot and killed, close friends shot and killed at a very young age. To Davion, death and violence were normalized. You're also going to hear from Dr. Rubino, and he's a neurologist. We had some PET scans and MRI scans done of Davion Murphy's brain. And he's going to testify that Davion Murphy has brain injuries, global brain injuries from multiple vehicle accidents, fights, other head trauma that he experienced from a young age and into his young adult age. And he's going to tell you that those brain injuries, and you'll see slides, and Dr. Rubino will tell you what those slides mean, but that those brain injuries cause him to have lack of judgment, lack of ability to stabilize his emotions, his inability to think about the consequences ahead of time, that he's a follower, not a leader. The first phase, you were decided whether or not Mr. Davion Murphy was guilty or not guilty. And he had the right, just as we all do, to defend himself. And as I said, we fully respect and accept your verdict. But during this phase, I'm going to ask you to consider all of the mitigation that we present on his behalf and consider him as a whole person, who he is today, how he got here today. Why is he sitting in this courtroom here today? Well, there's a reason. And I believe the mitigation that we present will give you that reason. And you should know that this is not a numbers game of how many aggravators the state has listed or how many that they've even proven or have proven or they've proven them all. Mitigation is individual to you, to each defendant, but individually a moral vote, the judgment that each one of you alone get to make. You guys will discuss the evidence, the mitigators and things of that nature, but it's each of you has your own vote. I hope at the end of the presentation of the defense mitigation for Davion Murphy, gives him the just punishment of life in prison without the possibility of parole. Because the aggravating factors are just, they're there. But it's not going to outweigh the mitigation that we present. So at the end, I'll stand up here one last time and ask that you vote for life. Thank you.
All right, very good. And at this time, Mr. Petridis, you reserve until the presentation of your evidence, correct? Okay, very good. Okay, state, call your first witness.
Your Honor, the state of Florida would ask to present victim impact evidence.
Okay, very good. Yep, come on up. Okay, so there's just a quick matter I have to take care of outside of your presence, and it's gonna take a little bit more than what I can do up here at the bench, okay? So, head into the jury room, I'll be with you momentarily.
All rise. All jurors are out, Judge.
Okay, very good. Okay, so, just please repeat again, what is the objection to the letter?
On the first page, looks like fourth to last paragraph where it says trying to process the loss that happens so suddenly and violently. I would just ask that the word violently not be included.
I'm sorry. Misstatements of yours.
Yeah, I don't see that either.
Yeah, I'm looking at it. I was sorry, Your Honor, I was looking at the computer version, so it's the paragraph is a little different. So it's a paragraph that starts, our family that also suffered tremendously.
Okay, and the sentence, next sentence reads, his loved ones continue to mourn him while trying to process the loss that happens so suddenly and violently. So what's the objection to the term violently?
Just the description that we found them guilty of the premeditated murder, asking for victim impact to comment on the nature of the crime.
I mean, it was violent, wasn't it? Mr. Harmon, what's your response?
Judge, I think there's overwhelming evidence in front of this jury that this was a very violent murder. And I think that this is putting into context the loss to this family. The state has redacted out already a couple of sentences that were not necessarily improper, but just to be on the cautious side, I would ask the court to allow this because she is trying to frame the loss to the family and explain it to the jury. She's not commenting on the sentence or what the
Right.
potential sentence should be or casting aspersions towards any of the defendants.
Okay. Yeah, I'll approve the objection, that's fine. Okay. Anything else regarding this letter before I bring the jury back in?
Not the letter, the email did say that there may be some photos, so I didn't know if there was something that we were.
Yeah, there's not.
All right, and are you gonna explain to the jury who this, is someone's reading
I
this on
am, Your
behalf
Honor.
of?
What I plan on doing is having him introduce himself where he works, and he is going to be reading the victim impact statement of the victim's mother, Sandrika Mays.
And does he need to be sworn in?
I can't hurt, I guess.
Okay, very good.
Oh, and Judge, is there some cautionary instruction the court's supposed to read?
That's a good question. Let me take a look.
I know it's in the final instructions. I don't think it's,
Yeah, let me pull it up.
okay.
Yeah, there is an instruction if requested, so I assume it's being requested. It is as follows. You will hear evidence about the impact of this murder on the family of Charles Jones. This evidence is presented to show the victim's uniqueness as an individual and the resultant loss by the victim's death. However, you may not consider this evidence as an aggravating factor. And I did give that same instruction in the initial instructions, but I can give it again. Or any of the, you want me to give the instruction again before this witness testifies again regarding victim impact evidence? I read in the introduction. I mean, there's no harm. I can do it again. Okay, I will. Okay, all right. We ready to go?
Yes.
Okay. Ready to go.
One in the restroom, Judge.
Okay. Okay.
All rise. Well, just rented.
Okay, you're good. Everyone have a seat. Welcome back. All right, again, ladies and gentlemen of the jury, you are going to hear evidence about the impact of this murder on the family of Charles Jones. This evidence will be presented to show the victim's uniqueness as an individual and the resultant loss by the victim's death. However, you may not consider this evidence as an aggravating factor. And sir, could you please raise your right hand? Madam Clerk?
Do you solemnly swear or affirm that the testimony you're about to give in this class will be the truth, whole truth, and nothing but the truth, so help you God?
Okay, have a seat. You may proceed, Mr. Harmon.
Good afternoon. Again, would you please state your name?
Hi, I'm Chris Jeffords.
Mr. Jeffords, are you employed at the state attorney's office?
I am. I'm a victim advocate with the Victim Assistance Program at the State Attorney's Office.
Mr. Jeffords, have you agreed to assist us with presenting the victim impact statement of Sandrika Mays, the mother of Charles Jones?
I have.
And do you have it in front of you?
I do.
Are you prepared to go ahead and present it and read it?
Yes, I am.
Please do so.
Yes. My name is Sandrika Mays, and I am the mother of Charles Jones. No parent is ever prepared for the pain of losing a child. The loss of my son has completely changed my life and the lives of everyone who loved him. Charles was more than what people saw online or heard in his music. To me, he was my son, a human being with a heart, dreams, flaws, and people who loved him deeply. He was a brother, a friend, an artist, and someone who still has so much life ahead of him. Despite the challenges he faced, he continued to work hard, provide for those around him, and pursue his passion for music. Since his passing, there has been an emptiness in my life that words cannot fully explain. I struggle emotionally every single day. Birthdays, holidays, and family gatherings, and even ordinary moments now carry pain because Charles is no longer here. I constantly think about what his future could have been and the memories we were robbed of making together. The emotional trauma from this loss has affected my mental, emotional, and physical well-being. Grief is something that I carry daily. No mother should have to bury her child. The pain does not end after the funeral. It follows you every morning and every night. Our family has also suffered tremendously. His loved ones continue to mourn him while trying to process a loss that happened so suddenly and violently. His death has left emotional scars that will never fully heal. Charles' death occurred 1 week after my birthday, 2 days before his birthday, and a month before his sister's birthday. The last time I physically touched my son was June 21st, 2024, 12 noon, when I traveled to Jacksonville, Florida to give him his birthday gift. I ask the court to remember that Charles was a person whose life mattered. He was loved deeply, and his absence has devastated our family. Our family wishes for the court to understand the seriousness of the pain and loss caused by his death. Sincerely, Sandricus Mays.
All right, thank you. Ms. Step down.
Thank you, sir.
Do any additional witnesses at this time?
No, Your Honor, state of Florida will rest upon all evidence presented in the first phase.
Okay, very good. Ms. Finkelstein?
Your Honor, the defense on behalf of Sean Gathright will call Raul Benasco.
Do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, very good. You may proceed.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon, how are you?
I'm good. How are you?
Well,
Good.
thank
Will you please turn and introduce yourself to our jury?
my name is Raul S. Banasco,
Spell your last name for our court reporter.
Banasco.
Thank you, sir. And how are you currently employed?
A variety of ways. I am a full-time jail administrator in Travis County Sheriff's Office in Austin, Texas, as well as an adjunct professor, and I do subject matter prison expert in jail security consulting work.
Can you please give our jury a summary of different facilities, jails, or prisons where you have worked?
I started my corrections profession in the state of Florida at the Central Florida Reception Center in Orlando, Florida as a corrections officer. Spent 7 years at that facility, moved up into the classification department as a classification officer, senior officer, and supervisor, in which I got promoted in 1995 to Polk Correctional Institution in Polk City as a senior classification probation supervisor, then went on to be the assistant warden at Martin Correctional Institution, maximum security facility in South Florida. And then after 3 years, got promoted to an assistant warden 2 level in Tomoka Correctional Institution, Daytona Beach for 5 years, returned on a lateral to Central Florida Reception Center, and got promoted to a warden at Hernando Correctional Center, Correctional Institution in Brooksville for women. And then shortly, about 1.5 years, got promoted to headquarters to the Department of Corrections headquarters as Director of Staff Development. And actually going back, I was a corrections officer at Lake Correctional Institution as my first assignment in Orlando in 87, and then moved on to run jails for the next 20 years.
And what type of education do you have to get into that kind of career?
To get in that profession, to be a corrections officer, of course, you have to have a high school diploma. I have an undergraduate degree in psychology from Iona University, as well as have my certification as a public manager to the Florida Atlantic University Master's Program, have my master's in public administration through Florida Atlantic University, and also have my credentials as a certified jail manager through the American Jail Association's Professional Commission, as well as my corrections executive certification through the American Correctional Agency through Washington Professional Certification Commission as well.
How long have you been, even up till now, working in this field?
Over 41 years, over 4 decades.
And I know you discussed you're currently working a capacity in a facility in Texas, is that right?
Yes, ma'am.
And what is that?
I supervise over a jail population of 4,000 inmates and about 1,100 employees. It's the 5th largest jail in Texas.
When was the last time that you worked in corrections in Florida?
Okay, last time I worked in corrections in Florida was 2010 when I was separating myself from retiring in 2010.
That didn't work out too well. I see if you're still here, right?
Now, 25 years, and then 6 months later, went back into the business.
From the time working in the Florida Department of Corrections specifically, did you become familiar in those capacities that you described to us with their department policies and procedures?
Yes, as a classification supervisor, particularly at the Central Florida Reception Center, which is Central Florida's hub, receiving almost 600 to 900 inmates a week from county jails and processing them out throughout the prison system, as well as my role as an assistant warden for 7 years and my wardenship and directorship. Very familiar. We all had to be familiar with warden assignments because we got moved when the agency needed you to be moved.
And Department of Corrections, that's a state-run program, right?
Correct. This is 3rd largest state prison system in existence.
So those DOC procedures will be pretty consistent from facility to facility.
Correct. They're pretty consistent. Maybe some SOPs might change a little bit on the design and the age of the prison, but they all pretty much operate the same.
And you indicated one of them, correct me if I'm wrong, was the warden of Hernando Correctional Institution. And was that with youthful and adult women?
Yes, I had a population of 350 youthful offenders from the age of 15 to 21, as well as the adult women population as well.
Why is there a separate prison for youthful offenders?
Every Sumter Correction Institution is the one for men. In many cases, we have to sort of segregate the youthful offender population with the adults, particularly in that facility, those individuals that were in the youthful offender program. There's certain expectations. We have to provide them particular education programs when we have them necessary, as well as, keeping in standard for safety purposes. We want to keep them separated because of their age and often because of their behavior. Between the age of 14 and 26, the behavior is sort of different in the prison setting compared to the adults.
And that was going to be my question. So 14 to 26 is what the department considered a youthful offender?
Yes, in the industry, that population, even though they are sentenced to an adult prison, I'm not a professional psychiatrist, but knowing the business, that's a very rambunctious. They're at a point in their life where they're still maturing. We tend to see that population have more disciplinary reports, more egregious behavior, more fighting that you have to deal with in that population versus the adult, that they're more settled and mature once they settle in.
And you also, as part of your career, you worked with as a juvenile case manager up in New York at some point, right?
Correct. I did 2 years with 2 contracts, one with Hawthorne Seed Knolls, which was mental health juveniles, as well as the other ones with juvenile group home children, my first employment in social services. Yes.
Based on your past work and experiences, I think I already asked you, you're familiar with the policies and procedures of both jails and prisons, specifically in Florida?
Yes.
And how, since it has been some time since you physically worked in the building, how do you keep up to be able to educate us on the policies and procedures of the Department of Corrections?
Well, it's been a while, but actually always a corrections officer at heart. In my current assignment, I walk the units and the compound on a weekly basis. Also keeping up with the Department of Corrections, particularly, still have a lot of friends and family members who work in the agency. So keep up with that in that way, but also keep up with the annual reports, as well as some of the changes that the agency goes through, as I'm familiar with a lot of the current leadership in different capacities because I came up with them, but keep up abreast with all the current changes going on that they have to publish as well in the agency website.
Okay, so in a little bit, I'm going to ask you about some specifics regarding life without parole and death row inmates in Florida. So are you able to give the jury that information based on what you've just described as far as how you keep up with those policies and procedures?
Yes, I am.
And before we get to that, so you're working now, other than what you've described in Texas, but you're testifying here today is it more in a consultant capacity?
Yes, it is.
What does
This
that
is-
mean?
Consultant means not in my work capacity is my role now, take actual time off to with consulting. We tend to always do this kind of work for retirement purposes. And I take on cases, either resentencing cases, penalty phase cases, even some civil cases where there's some wrongful death involved, either for the agency's defense or for the actual plaintiff as well.
And I assume you're not doing that work for free. Can you tell us how much you charge per hour?
No, my fees are $200 an hour to interview, review records, as well as $225 an hour to testify and $110 to travel time as well.
And that all gets approved when we get you onto a case?
Correct. Everyone that I work with, regardless if it's private or government, there's an agreement and that the hours are authorized in advance.
And have you previously testified in court before in that capacity?
Yes, I have.
And do you know approximately how many times?
I'm sorry, Your Honor, if I could ask just what capacity, because we covered a lot of.
Sorry.
Thank you.
As a consultant?
As a consultant, over 55, 60 cases,
And was that in state and federal court?
state and federal, as well as county as well.
And was that just in Florida or anywhere else?
No, I've done work in South Carolina, the state of Georgia, Texas, Florida, of course, even done some work in Louisiana as well.
And have you always been allowed by those courts to give an expert opinion in the area of corrections policy, practices, and conditions?
Yes,
Your Honor, at this time, I would ask that the court allow Mr. Bonasco to give his opinion testimony in the areas of corrections policy, practices, and conditions.
Who's your body of witness this time?
No, Your Honor.
Okay, you may proceed.
Thank you, Your Honor. Have you ever consulted on cases for the prosecution or state attorney's office?
no,
Okay, now I'm going to get into some specifics. We talked about the difference between a life without parole sentence and what a death row inmate. Let's start with life without parole. Throughout your lengthy career in corrections, have you become familiar with how inmates serving a life without parole sentence are housed in the Department of Corrections?
yes, I have.
Okay, and can you tell us physically how they are housed?
Well, all my assignments in the Florida prison system were all at lifer facilities, so I'm very familiar with that layout. What happens is an individual who is sentenced to the Department of Corrections, particularly like in this case with Ms. Garthright, he will go through a reception center process. He will be given an inmate number. That inmate number will remain with him
Man,
for the
you can
remainder
tell
of
he
his
nervous
sentence
as
while
fuck.
in the prison system. They will then be transferred after 6 to 12 weeks, in which they go through a reception process. They have to see all components, medical, mental health, social services, and classification, and we assess their custody level, and then we will assign them to vacant beds throughout the prison system. When that individual were to be received at a facility, let's say Tomoka Correctional Institution, which is a lifer facility, holds all custody levels to close, that individual will be classified and assessed based on their skill set, their behavior, their prior behavior, whether it's in the county jail or in another system, in another agency, and then determine their housing assignment, determine their job assignment, in which every inmate that is serving a term of life will always have to be assigned a job assignment. So what that means is every inmate serving a life sentence is required to work up to 60 hours a week, whether it's cooking meals, preparing laundry, pushing about 100 lawnmowers, gasless, of course, keeping up with the day-to-day maintenance of that prison. That is a requirement, as well as following all the other rules and regulations as required by the agency.
So part of the classification, and I know probably just out of habit, you said we, you obviously aren't
Yeah,
working there
right,
anymore, but
department.
the department will find a facility where Mr. Gathright would be the most useful
Yes,
and fit in the best?
yes,
And also they have programs and things you mentioned, right?
yes, they have programs.
Can you explain what a typical day in the life of an inmate serving life without parole would look like, since they are required to work? What else does a day look like?
A typical life for an individual inmate serving in the Department of Corrections is they're woken up at 4:00 in the morning. We do a secure account. At that time, we will escort them to their appropriate chow hall, which is where they eat their meal. They have up to 10 minutes to sit and eat their meal. They will return back to their housing unit, in which we will conduct another count. And then we will allow them to go to the day-to-day operations. So inmates have work assignments. They are to report to their work assignments as scheduled. If they have call outs for medical, classification, case management, they are to be accounted for, and we will go through the same process 3 times a day. So closer to the noon meal, around 11 o'clock, everyone will fall into their assignment. Those who are working, regardless of where you're at, we will do a count. We will go through the lunch meal, and then we'll repeat it again around 4:30 approximately in the evening, so we can make sure everyone's accounted for. Then they return back to their housing unit, and after dark, they are all secured in secured housing, and no inmates are allowed to be out of those buildings unless there's an emergency with proper security, shackles, and handcuffs to whatever assignment they have to go. Otherwise, they remain in those housing units till the next day, in which it is repeated again.
So they're not just roaming around the prison all day. looking for
Absolutely
things to
not.
do.
They tell when to do, what to do, when to do it.
I didn't hear you mention a shower. Do they get to shower?
They get to shower. We are required by accreditation standards to give them a minimum of 3 showers a week.
How's it going, Stan?
Because those individuals are in an environment where they don't have
Yeah,
their
they
own
just trying
showers.
to beat that
It's
death
based on
penalty.
who the population is, usually about 250 inmates for like 7 to 10 showers. So they're sharing spaces.
And I don't know if you might have mentioned this, but the housing itself, are they in a dorm style or what does their personal housing look like?
Their
Or
personal
room?
housing is, Department of Corrections, we know it as HO5 and HO4 housing. That's the housing assignment we give individuals who are serving a life sentence. An HO5 is an individual cell that's designed with 2 men in it. That's more the old prison style. Like I worked at Tomoka Corrections in Polk, old prisons because of the design at the time. Because we've had individuals serving life, we also code them, the Department of Corrections codes them as HO4. HO4 is the same type of secure housing, but these individuals are more in a communal environment, almost like a military style. The integrity of the building is still designed to hold lifers, but because a lot of the old prisons, the footprint is very antiquated and very manpower intensive, we have other type of industry standard housing, so that they are in an HO4 status.
If someone is sentenced to life without parole, meaning they're not getting out, is there any incentive for them to follow the rules while they're in prison?
Well, every inmate in the Department of Corrections is required to work. And if they do not show up to work, even those who are medically indigent, they're required to work. They will face administrative outcomes, basically receive a disciplinary report for refusing to work. And if that continues to escalate, we move them into
In other
another
words,
level
they'll
of
be
status
sitting in their
based on the
cell for
classification and
23 hours a day.
negative adjustment in the prison setting.
And what would be their incentives to follow the rules other than just where they're housed? Do they get any benefit for following the rules?
They would have their privileges not revoked. Privileges such as family visits, commissary, inmate tablets, access to the TV, those even access to programs. Those are the privileges in which they have to follow the rules in order to keep them.
And so you indicated that they are required, those inmates would be required to work 60 hours a week, and even if they're disabled. Is it safe to say that prison can be made even more comfortable for a person, or uncomfortable, sorry, if they refuse to work or they're not following the rules?
Yes, in the system, it's designed, if they continue to refuse to show up to work or their assigned area, they will get disciplinary reports. As they continue to escalate those disciplinary reports, then they will be considered for close management. And what close management status is, those individual inmates in the prison system that are not following the rules, they become a security concern, not only for the other inmates, but the day-to-day operations, at which time the institutional classification team will review them, place them on a docket, as they say, to be reviewed by central office, and move to a facility such as Santa Rosa Correctional Institution, Martin Correctional Institution, Columbia, to name a few, in which they house close management 1, 2, and 3 statuses. These individuals, for the most part, are locked in a single cell by themselves. They don't have any privileges, just to see medical every day, as well as their meals, and not even but twice a week get uniform and allowed out of their cell 3 times a week. They will remain in that status till they start complying with the rules and regulations, in which they will eventually, hopefully, move out of that status if they start conforming to the rules.
And you gave some examples earlier. I just wanted to follow up some of the things that inmates do in the way of work at the prison. You included cooking, is that right?
Yes, we have to prepare 3 meals as well as even dietary meals for the inmate population. So we use a lot of the inmate labor to do all the meal preparation as well as keeping up with sanitary requirements. We have to launder all the food as well. We have also inmates, the department has to inmates who have skills in maintenance because the Department of Corrections utilizes 80% of the inmate labor to keep up with the aging facilities that the prison system has. That's something on a national level. We put them to work. They do not have any kind of financial compensation they're required to. We also keep up the grounds as well as utilize them in different capacities. Those who might have a high school diploma might be part of the orientation for the new inmates coming into the prison system, sort of like a peer-to-peer, helping those, particularly those coming in with a term of years, to hopefully take advantage of the programs and not return back to the prison system.
You mentioned yard work. Do they do painting, electrical work, things like that based on their skill set?
They do plumbing, painting, electrical. Keep in mind, they're under supervision of what we know as a vocational instructor. So they're not freely having any access to tools. They are always supervised. Because of a prison design, things do break down at night. So sometimes, depending on the skill set, staff is dispatched, or even the corrections officers have to supervise them to keep up with these repairs. Wastewater treatment programs, some of the prisons in the Department of Corrections, I know personally have been assigned to places where we don't have direct water access, so we have our own water and treatment programs, so we have to keep up with that as well.
You indicated that the inmates themselves don't make any money or commissary off of that work. Is that right?
No.
Would you say that they save the Department of Corrections in the state of Florida money?
Yes, they do.
Because you indicated, I think, 80% of the work done is done by inmates?
Yes, I mean, keeping in mind, we're talking almost 80 prisons throughout the state of Florida and the aging buildings that they have. If it was not for the inmate labor, it would be quite challenging and financially a challenge to the agency to keep up with all the repairs.
Do they do anything that they can contribute outside the prison? Is there any work? I know, and this may be like way old school, we'd see inmates making like license plates. They probably don't do that anymore, but are they doing anything for people outside of the prison?
Actually, they still do license plates.
Oh, they do?
Yeah. In my years and still to this day, we have different events. So actually, we use inmate laborers who might have some carpentry skills. They actually do a big thing every year in different agencies throughout the United States for Toys for Tots. We also use them to create the inmate uniforms, their inmate boots. We keep up also refurbishing of vehicles. When I worked at the women's facility, the women there did the eye contacts and the dentures for the prison system. So we utilize them to work through our partnership through PRIDE, the Prison Rehabilitative and Industrial Enterprise company that is a partnership. We put them to work with this particular partner to keep us sustained and also cost saving. They also do the furniture at Polk Correctional Institution. For those agencies that want to buy furniture, there's a furniture factory there as well.
And PRIDE, I think you said, is a Prison Rehabilitative Industrial Diversified Enterprise?
Yes.
That's a mouthful, but okay.
It's a lot.
So an inmate sentenced to life without parole, would you agree, is a resource for inside the prison as well as society in some cases?
Yes.
What about, you talked about visitation and some incentives for following the rules. What are inmates in prison allowed to communicate with people on the outside, and if so, how?
Yes, they are allowed. There's the new industry standard. Typically, they can call on the phones in which they can call out, but also we have tablets. It's the new industry standard. Inmates are assigned a tablet in which they can either do video visitation in some facilities and even text in a secure server to communicate with their family members as well.
And I assume that's all monitored by the department.
Completely, yes.
And is it free to the inmate?
No,
The tablet's free, but the communications aren't, is that right?
correct. There's a fee for the text as well as any kind of communication with outside folks.
Now I want to move on to talk to you a little bit about if someone's serving or they're sentenced to death and they become a death row inmate in Florida. How is an inmate on death row housed physically?
Physically, when you're housed in a death row environment, particularly at Union CI, go there often. They're housed in a 6x9 cell, single person housing with a mattress, their assigned TV, stainless steel sink and toilet, as well as our provided services. They also, 3 years ago, changed the process in which now inmates on death row also are allowed and issued a tablet, as well as they're allowed a lot more time out of their cells as historically, and also have family visits. Their food is delivered to them and their uniforms are delivered to them, but they're not required to work.
Let me just take those a little bit one at a time. So you said the TV, do they have their own TV?
Yes.
What about the inmates that are serving life without parole? Do they get their own TV?
No, each side of the dorm or each pod or quad is, depending what you call it, the department has to share a TV in that environment. So there's often fights and stuff, but they basically, amongst the prison population, have to determine what channel of the limited channels they can see.
But somebody that's on death row will have their own TV?
Yes.
And do they go to the chow hall to eat, or you said they get the food delivered to them?
Their 3 meals are delivered to them on the road.
Do they do their own laundry?
No.
So somebody else, the inmates that are working, do their laundry and bring it to them?
The inmate laundry is done by the inmate laundry trustees, as we often call them, and they will be delivered on a weekly schedule, exchange their uniforms.
And I believe you said that they are not required to work. Are they able to work?
They're able to work, but they're not required to work.
Do inmates sentenced to death contribute to the prison workforce in any way?
No.
So let me turn your attention to Mr. Gathright, Sean Gathright. Did you have an opportunity to meet with him?
Yes, I did.
Okay, do you recall when that was? And you can look at your notes if you need to.
March
refresh.
1st, 2026 at the Hillsborough County Jail.
And what was his demeanor just generally when you met with him?
Very pleasant, a young individual who was very articulate. We spoke, he was very respectful, had a good meeting with him.
And I assume you know that he's relatively young, at 20 years old right now.
Yes, he was booked at the age 18, he's 20 now.
Did you learn through records provided by my office that Mr. Gathright was a high school graduate?
Yes.
Let me ask you a little bit about that. You mentioned earlier in your direct about somebody with an education. Certain inmates can maybe be kind of mentors or peer-to-peer, I think you described it, working with inmates that are serving a term of years, meaning they are getting out of prison. Do you think that Mr. Gathright would have that ability if he were serving a life without parole sentence?
He would have that ability. Of course, classification will have to look at his behavior, but the fact that he does have a high school diploma, that is one of the requirements to be an inmate student aid, because they're helping other individual prisoners obtain some kind of education programming. So they have to have a high school diploma. So he does have the credentials to be considered for that type of work assignment.
And as you said, when he gets to classification, somebody there will make all these determinations once they evaluate him physically, mentally, behaviorally, all of that stuff, right?
That's correct.
And based on your previous work as a classification officer, you feel comfortable saying that he could potentially be in that role?
Based on my experience and 4 decades, someone who I met and got the opportunity to speak to, and his current housing assignment, he has the potential to be considered for an assignment like that once in the prison system, but that would be over a period of time. Every inmate who's brought into a permanent prison will have to go through a period of observation, and usually they start on inside grounds for the first 3 to 6 months, and depending how well they do out in the heat and behave and follow the rules, then they can be considered for other positions which have more responsibilities or level of trust, but always supervised by staff.
And in the Department of Corrections, are there also what you consider faith and character facilities?
Yes, that is a new industry standard in the last 5 to 7 years. The Department of Corrections has quite a few of those that are spread out throughout the state.
And what do they offer to an inmate serving? Well, I assume they don't include death row inmates, but if somebody's serving life without parole, what would that mean?
Anyone in the prison system up to life is eligible to be considered to go to that facility. For example, you have a Sumter Correction Institution, Everglades Correction Institution, but you have to show a 2-year record of following the rules, no disciplinary reports, no kind of security concerns, just to be considered. There's an application process in which they will have to go through, because these facilities, they're also known as incentivized prisons. So they only want those inmates who are respectful, following the rules, and not going to be a security concern.
And based on Mr. Gathwright's age, physical abilities, things like that, do you think that the prison would benefit from him in a work capacity if he were sentenced to life without parole?
I say yes, with my experience, not only just in classification, but as a former warden and even as a jail administrator. He's someone that's young, he's healthy. In reality, we need that labor, we need that sweat equity, and we will put him out there to work because we do have an aging prison population, jail administration. We have that. So we put these young individuals to work and get some sweat equity out of them since they are young and actually can do the work.
And I know we talk about life without parole and death row, but for our jurors' education in Florida, what does a life sentence without parole mean?
A life sentence in the Florida Department of Corrections means from the minute they're brought in, they're assigned an inmate number. He will be assigned an inmate number, and when he dies and leaves in a body bag, he will still have that inmate number. An inmate serving life will never, ever get out. There is no parole in the state of Florida, and they're not ever allowed outside the razor wire and the fence of a secured facility.
So the only way that an inmate serving life without parole would leave is when they die by natural causes.
Objection, Your Honor, asked and answered.
Sustained.
Your Honor, may I have a moment?
Yes.
I'll talk to the witness.
Okay, very good. Mr. Harmon?
Good afternoon.
Good afternoon, sir.
Mr. Bonasco, you throughout your testimony have been using the term "we" when you're talking about the DOC. You keep doing it. You're no longer employed by the Florida Department of Corrections, correct?
That is correct.
All right. And you separated from a corrections job here in Florida in 2010, but that was a county corrections
Correct.
job, correct?
Yes.
You separated from the Department of Corrections in 2006,
Yes.
correct?
Yes.
So 20 years ago, right?
Yes.
All right. So it's been 20 years ago since you have worked as an employee of the Florida Department of Corrections.
That is correct. Yes.
Since you have stepped foot into a correctional institution in this state as an employee, right?
Yes.
Okay. Now, you've talked about you have previously testified as a consultant, and I believe counsel asked about your expert opinion in corrections or in security, corrections security.
Corrections, security operations, anything to deal with corrections, detention, prisons, and jails.
The 55 times that you've testified, that has included testifying in civil cases, correct?
Yeah, a handful, yes, sir.
Testifying in cases where people have filed lawsuits where someone's been injured or hurt in a jail or in the prisons.
Yes.
That's included testimony in non-capital criminal cases.
That's correct.
When did you start testifying in criminal cases?
In criminal cases?
Yeah.
Oh, it's been
Criminal
over
cases.
10 years. but-
Over 10 years.
Mhm.
All right. And you didn't start testifying in cases like this penalty phase of a capital murder case. You didn't start doing this until about 5 years ago, right?
Approximately 5 years ago, yes.
So how many times have you come into court in a penalty phase setting like this and testified?
Over 40 times.
In a penalty phase?
In a penalty case, about 20 cases.
Over the last 5 years?
Yes.
You were asked about the typical day in the life of a person who has been sentenced to life without parole here in the state of Florida, right?
Yes.
In the prisons, correct?
Yes.
And you would agree that when the person is sentenced and they're transported, they go to a receiving facility, correct?
From the county jail?
Yes.
Yes, they go to a reception center.
A
Yes.
reception center. And then, I don't know, are they classified there or do they go to some other facility where they go through classification?
No, every prisoner goes to the reception center and they will classify them and assign them to a permanent prison.
To a permanent prison, right. And that's done by a classification specialist of some type?
Classification officer along with their classification supervisor.
And once they get into a prison, when they're assigned to their prison, they will be observed and they will be watched and monitored and documented, as you said, as they go through their day-to-day activities, correct?
Yes.
Over the course of the time that they're in that facility, right?
Yes.
And at about 6 months approximately, they're going to be reevaluated, right?
Right, anywhere from 3 to 6 months. Now, of course, to clarify, if they're not adjusting well, they will be reassessed sooner than that.
But they're, okay, that's true. Okay, if they commit some offense or they violate some major rule or they start accumulating DRs, disciplinary reports, that may accelerate that classification or reevaluation. Is that right?
Yes.
But at some point, even if they live spotlessly clean, follow all the rules, they are a wonderful inmate, they do everything right, they're going to be reclassified at some point within a year.
Well, particularly in this case, when you're serving a life sentence, at a minimum, you have to have an annual review. So basically, they have a reassessment annually just to make sure they're keeping up with their behavior and touching base with any needs as a case manager would do.
Right, and I misspoke. They're not necessarily going to be reclassified, but they're going to be reassessed, reevaluated.
Yes.
And that's done by a classification team or a specialist in that facility.
Right. The classification officer will review them, and then the paperwork goes to the institutional classification team.
So if a person is sentenced to life without parole for a capital murder, like in this case, same kind of charges we have in this case, and they go up to the reception center, they're normally going to be sent to a facility, correctional institute, and they're going to be at a fairly high level of security level, right?
Every inmate serving life will be nothing less than close custody.
Close custody, right. And once they've been there for 6 months, 8 months, whatever it takes, if they're following the rules and they're doing what they're supposed to do, and they're not accumulating DRs, they're going to be reevaluated, right?
Correct.
And there may be modifications to their job assignments, correct?
Correct, based on institutional needs.
Institutional needs, right. And you said that most likely if someone is sentenced to life, the first thing they're going to be doing is probably pushing a mower outside, working outdoors, doing some kind of manual labor, right?
Correct. Inside grounds is the go-to assignment. It's in the heat, and that's where we need the most labor
Right.
to get things done.
And a lot of these facilities, even the ones in North Florida in the summer, they get pretty hot, don't they?
Every one of them.
So they're going to be out there in the heat getting pressure tested as far as their ability to maintain what they're supposed to be doing their jobs, doing it right, being disciplined enough to follow regulations, right, and rules.
Yes.
And again, that's something that's being assessed over time, right?
Yes.
I was trying to find the term you used, a period of observation, correct?
Yes.
All right. Now, you work in Texas, is that correct, sir?
Yes, I do.
In Austin, right?
Yes.
What county is that? Tarrant County? Is that
No,
right?
that's Travis County.
Travis County. You did work in Tarrant County.
Tarrant County's Fort Worth, yes.
Fort Worth. And you also worked in San Antonio.
Yes,
Is that
Tarrant
right?
County.
And you worked in St. Louis for the
Correct.
jails up there, correct?
For 10 months.
You worked
Horrible
in
experience.
Osceola County,
Osceola Jail Commander and Orange County
and
Corrections
Orange
as the
County
major.
Corrections. You've had a lot of corrections jobs where you've worked for about 2 to 4 years and then moved on to other jobs.
No, the agency, the department, I was on 19 years, did 2 years with Orange County Corrections, promoted to Osceola County, did my additional 2.5 years and retired.
That's when you retired out of
Retired.
2010.
Had to deal with the unfortunate escape and fire folks, and my mother was in hospice. And then actually, just to clarify, then went on to work with Bridges of America for 2 years, which is a reentry program that contracts Department of Corrections for 2 years. And then I was tapped on to be the jail administrator in Bexar County for almost 4 years. And individuals like myself, we serve at the will. So the elected official sheriff was not reelected. So the administration that's appointed has to find another opportunity in which the sheriff in Tarrant County asked me to be the jail
Okay.
administrator.
I thought you said Bexar County. You said
Bexar,
Bexar County.
Mhm.
Okay. And those are in Texas,
that's in San Antonio, yes.
San Antonio. And Tarrant County is which major
Fort
city?
Worth.
Fort Worth. All right. But you work in Austin, but you live in Tallahassee, correct?
Correct. I commute every few weeks.
Have
My
you
home
done-
is in Tallahassee.
Have you done that through all your jobs in Texas?
Yes.
Kept your residence here in the state
Well,
of
yeah, because
Florida?
my wife and family reside on and off in Florida. So I even did it when I went to St. Louis, did 10 months, but my family didn't relocate to that assignment.
So you were in St. Louis for 10 months, for less than a year?
It's a tough assignment. That's all I wanted to do was 10 months in St. Louis.
And in addition to doing that, as you told counsel when she first asked what you do, you started consulting, right?
I've been consulting since 2000. I'm a national American Correctional Association national and international auditor. I've done over 300 prison and jail inspections in state.
Well, I'm sorry, I didn't mean to cut you off, but I was talking about consulting in legal cases. I should have been more specific.
Okay.
At some point, you started consulting in legal cases.
Correct. It could have been
Okay.
2014 is when I started doing more of the legal side of it.
So when, getting back to what we were talking about, when you worked in the DOC, you either trained on or you supervised the people who were doing these classifications, correct?
Yes,
The teams, the classification specialists or coordinators,
all that.
fair to say that? Yep.
Yep.
Okay. And like we were talking about earlier, they're reviewing, and you correct me if I'm wrong, the security level for that person? Or the-
Correct.
the custody level?
Yeah, what happens is we review, first of all, the term that they're sent to the prison system will determine their custody in many cases. So someone who serves life, you will always be close custody. That's just, the system is designed that way. Depending on other inmates coming in the system, if they have a term of years, they also look at that. If their charges mitigate, all those things to determine their custody level.
And a lot of it or most of it is based on their adjustment, right? How they're adjusting.
Their adjustment as well as their prison sentence, as well as
Right.
their prison.
But I mean, they're continuing, when you're reassessing a person's status and how they're going to live in the custody or that institution, they're looking at how they're adjusting to prison life over time, right?
Yes.
And they're looking for a continuous positive behavior on the part of the inmate, correct?
Correct. Starting from the reception center, because when they come in 6 to 12 weeks, they might not get to their permanent camp. So they are assigned a job even at a reception center. If you're there more than 10 weeks, you have to get a job assignment. So they actually start now assessing them even at the reception center pending going to their permanent facility.
So this to be, just to phrase it another way, they're looking at the sentence, they're looking at the history, but they're also looking at things like, do they have a high school degree, right?
Yeah, they look at their education. They verify that through
Right.
their database to make sure if they have any kind of education. They also gather their skills, any kind of employment. because when we get weekly I'm gonna correct myself, when the Department of Corrections gets weekly allocations, it's like a factory line. On Mondays, they get an allocation list. We're flushing out 590 prisoners out of the system, but one facility needs 50 cooks. Another one might need 12 plumbers. No matter the custody level, depending on main institution, then the Department of Classification team will try to fill those allocations because we want to empty the reception centers, but also the department needs to fill the vacancies and the needs for those facilities.
So a lot of it's need-based, from what you're
Yes.
saying? Okay.
Yes.
You spent, in this case with Mr. Gathright, an hour and a half with him, correct?
Yes.
And you've told us some of your impressions here a few minutes ago.
Yes.
Yeah, let me just go through that with you. You found out at some point that he has a high school degree, correct?
Yes.
You found out that he had prior, I guess, worked in the catering industry, may have culinary skills or
Yes.
some level of culinary skills.
He worked at Oxford Country Club as a prep cook. He did some other work. During my interview, he did work in the hospitality industry.
At a country club.
Country Club in Oxford, Mississippi, I think it was, yes.
And you found him to be very articulate, correct?
Correct.
He was very cooperative with you, is that correct?
Yes.
In fact, he graduated from Oxford High School in Mississippi, correct?
Yes, in 2023, I think. Yes.
He also worked for the Omni Hotel, is that right? In catering?
Let me double check. He didn't mention that. He did tell me he worked for Oxford Country Club, well, also a sushi place and Central Plate Catering Service, unless that was a contract with the Omni Hotel, which some of them do. Not familiar.
If you had said at a time in the past that he did work for the Omni Hotel, would it refresh your memory if I showed you that?
Sure.
May I approach the witness, Your Honor?
Yes.
And it's page 23, counsel. It's deposition.
Let me see if I can find it. Oxford, Omni. Yeah, I did mention Omni, but in my notes, as you see, well,
Do you think that the Omni that you came up with may have been something someone told you maybe, even if it's not in your notes since you testified to it
no,
in
I
the
really,
deposition?
and I don't even stay at an Omni Hotel, but I don't know where that one came from. I'm trying to look at my
Okay.
notes. No, Central Plate Catering. I don't recall.
So he had experience working in catering,
And serving,
serving,
prep cook.
prep cook. All right. Do you remember telling me in your deposition that I took of you that you were impressed by him
Yes.
and you found him to be a very mature person, a very mature young man?
Someone 20, yes, he came across very mature.
Now, when you work for the Department of Corrections, you work for a lot of institutions, a lot of correctional institutions, correct?
Yes,
And when I say worked for, all of that's the Department of Corrections,
yes,
statewide agency, right?
yes, sir.
Maintains our prison system. Is that correct? All right.
Yes.
So I think you said you worked at Tomoka, you worked at Martin. You mentioned Santa Rosa. You didn't work at Santa
No,
Rosa.
no, I
though,
worked
right?
at Polk CI, Polk
Polk CI.
Corrections too,
Okay.
Martin, Tomoka, Hernando.
Union Correctional and Florida State Prison, both located in Rayford or right there by Rayford. Familiar with them?
Yes, I
All
am.
right. You were never permanently assigned to either one of those, correct?
No,
You visited them as part of your job. You went there for training, I believe. You may have been there for other reasons, but you were never permanently assigned there.
never permanently assigned.
Never permanently assigned to death row, correct?
Correct.
And when you worked there, when you left in 06, death row was housed for men, was housed at Union, correct, in Rayford?
Yes,
And literally almost down the road at Florida State Prison, which is a prison that's actually called Florida State Prison, correct?
FSP.
Right, FSP. Now death row is housed exclusively at Union Correctional, correct?
Yes,
You have not viewed the inside area of death row or had access to that in over 20 years, correct?
correct.
Death row conditions, would you agree with me that that is maximum solitary close custody?
It is maximum security, close custody. I don't know if the word solitary, that's a
All right.
word we don't use in the industry anymore because.
Right.
Right.
Well, the common meaning solitary, meaning that they are housed individually in their own cells, correct?
Yes,
You indicated earlier the cells are 6 feet by 9 feet, correct?
approximately, yes.
All right. And in death row, there are 6 wings, each with 2 levels, 8 cells per row. Is that correct?
That's correct. That's my
right.
understanding.
You mentioned steel toilets and sinks. The toilet has no lid, correct?
Stainless steel toilet, yeah, no lids, industrial corrections toilets.
They have a steel bed with a thin mattress, correct?
Correct.
And they can have a radio if they wish, correct?
Also, they also, often many of them just use the tablets because you can get music on tablets.
The
as well.
tablets, all right. I'm going
Yes.
to talk to you about the tablet in a minute. They are issued tablets. Let's just go ahead and talk about it. They are issued tablets. The tablet is, it's like it sounds. It's like a pad, electrical pad or tablet.
It's a hard book.
Right. And it has limited content on it. You can read books on it. There are some programs you can watch on it, but there is availability to purchase additional things you can watch on it for money, correct?
Yes,
So you have to have that money in your commissary or canteen. Is that correct?
that is correct.
So somebody you know outside of prison has to put that or donate that or deposit that into your account.
So they may trust account, yes, sir.
Okay. They have no access to any kind of internet connection with that tablet, correct?
That is correct.
They are issued their own TVs. They are little 13-inch cubes, correct?
Yes,
And those work off of an antenna, correct?
rabbit ears, as we often call it.
Just like the larger big flat screens that are mounted in the general population or I'm not saying that right. I know that's not the term.
The day
Open
rooms,
population.
in the day rooms.
Yeah, well, let me go back to open population for non-death row. They have bigger TVs that are mounted that they watch communally, I guess.
Correct, it's general population.
Right. But with both of those, they're working, especially these little small TVs are just working off an antenna, right? Like
Yes.
little rabbit ears.
They're
Right?
the same channels that everybody else would have.
Just a few channels. They're not getting a streaming service or cable, correct?
That is correct.
All right. Now, their food, they are fed 3 times a day, correct?
Yes,
First, breakfast is at 5 a.m., correct?
roughly, yes.
Lunch is from 10:30 to 11, is that right?
More or less. Yes.
Dinner from 4 to 4:30 p.m.
Yes,
Those meals are brought to them on a plastic tray, is that
yes,
correct?
yes,
And they are slid through and they eat them in their cell, correct?
yes,
They don't leave their cell to go eat somewhere, correct?
that is correct.
And they are given what's called a spork,
Spork, yes.
a plastic spork, correct?
Yes,
That's all they're given. They're not
Yes.
given any cutlery of any kind, correct?
absolutely no.
And that would be the 3 meals they're going to eat every day moving forward, correct?
Like
The
the
way
rest
they
of
eat 'em.
every inmate, yes,
Those are prepared by institutional food service, correct?
yes,
Is that other inmates?
yes, inmates prepare the meals.
So they're eating them when they're secured in their cells, correct?
Yep.
All
I
right.
think from time to time, keeping up with some of the changes, they might have 1 or 2 eat in the day room, the trustees helping, but majority of them eat in the cell.
Now, they're allowed to have snacks, correct?
Yes, commissary items, yes,
But they have to purchase those from the commissary
correct.
with money deposited into that account. Is that right?
Yes,
All right. There are times when they're allowed out of that cell, correct?
yes,
And you talked about that because there was a civil legal settlement back in 2022 that expanded their time out of the cells, correct?
yes, sir.
They can go to what's called the day room, right?
Yes,
And that's every day, Monday through Friday for 3.5 hours, correct?
yes.
And that is that entire row, so 8 or 7 inmates, correct?
7, 8 inmates in the same common area,
Right.
if they choose to leave the cell.
So the common area is basically a cell, just like the one they're in, that's in the middle of the row. That's an empty cell that has things in it like a kiosk, a TV, a card table, right?
Now, when you say the middle cell, you're talking about the day room environment?
The day room.
Yeah, it's sort of an area, but it's not a cell that everyone goes into. It's a common area.
It's about the size of a cell, though.
About
right?
the size, very small, but it's
Very
a common
small.
area where the officers are supervising them. They're not like in a cell.
So these inmates, during that time, they can also elect to go use one of the phones on the row, right?
Yes.
On that row. Or they can elect to take a shower, correct?
Yes.
To go have a shower. And like all the other, they get 3 showers a week, but they can elect to use that day room time to get a shower, right?
Yes.
The kiosk that is in that day room, there's a similar kiosk in their recreational area that they're allowed to go to during the week too, right?
I think there is, but I can't confirm that.
But the kiosk allows them to make purchases. It allows them to make phone calls with money.
I know the
Deposited-
kiosks that you're referencing, my understanding, those kiosks, unless you're talking about the wall mounts, most of them are only there to communicate, get your balance on your inmate account, as well as order commissary.
Order commissary. All right. So other than the day room time, if they're going to take a shower, they have to take it 3 times a week. Is
Correct.
that right? Okay.
They also have recreation time as well.
They do. So I want to talk to you about that real quick. That's 2 times a week for 3 hours, right?
Correct.
And I think there's about 20 inmates at a time that go out on that rec area.
Yeah, my understanding, they try to keep it at 15, but 20 is the max.
15 to 20. Okay, 20 is the max, right? And the rec area has a backboard,
Yes, they do.
and it has a flat area there where they can shoot hoops, play basketball.
Yes, sir.
All right, but it's not full court.
Absolutely not. No.
Okay. And I think there's a dipping and chinning apparatus that they can share or utilize, correct?
Yes.
And it's open air.
Yes.
Visitation is on the weekend, if they're allowed to have visitation.
And during the week, I've visited many times, and families do come up during the week as well.
That has to be pre-approved, correct?
By the warden, yes, sir.
But there are hours on the weekends from, I believe, 9 to 3 where they can go and be visited, correct?
Correct.
So other than what we've talked about, staying on their row where their cells are lined up and going to the day room or going to the rec area, anytime they leave that cell, they are shackled, correct?
Yes.
And that would include leg irons, waist chains, and cuffs to the waist chains, correct?
And a black box.
And a black box between the hands, right?
Yes.
So they're going to be walking like this,
Yes.
and they're going to be escorted anywhere else they go.
With 2 officers.
When they go to visitation, to visit someone on the weekend, they're escorted to a search room where they are searched and monitored, correct?
Yes. Going in and out.
And then they're allowed to go into this open area, which I think has a maximum of 22 or 23 inmates,
Correct.
where they can meet with their families.
Across from the table.
On average, inmates on death row spend 21 hours a day, on average, in their cell.
Well, depending on the week, on the day, it can be as less as 16 hours, but depending on if that's the day room, and also keep in mind, they can put a request to go to the library as well now, in which they have to be escorted. And they can also say they had a medical emergency. So I don't want to quantify that because every day is a different day. But
Right.
I would honestly say anywhere from 15 to 21 hours is about the average.
And no matter what, they are always under heavy surveillance, correct?
Yes, because of their custody level.
What is their custody level?
They are any inmate who is sentenced to death row is maximum security level.
All right. And they are you talked about head counts in general population. The inmates on death row are counted hourly, correct?
Yes. Mhm.
Every hour or at least every hour on the hour, correct?
They also have informal counts as well.
They have, you would agree with me, a strictly controlled daily routine, correct?
I would say yes.
All right. And there is no air conditioning on death row, correct?
Well, no. There is air conditioning on death row. As far as the housing units, not like a general population prison environment. We don't have death row. They do because of their housing category. Yes.
There's no AC, right? No air
Well,
conditioning.
they do have, I want to say not AC, but they do have some kind of bed exhaust system because they spend the majority of their time in a housing environment versus a regular prison. They're allowed to go outside
But
onto the complex.
it's not air conditioning though, the way
No.
that we would understand air
No.
conditioning.
Not like
Okay.
we would do at home. No.
I believe you answered this, but to council's question, in the times that you told us that you've come in penalty phases and testified, I think you said it was 20 times over the last 5 years.
Approximately, yes.
And you've given similar testimony to what you gave today? About
Yes.
the conditions within the Department of Corrections?
Yes.
Okay. You've never testified in those cases for the state or the prosecution, correct?
No, never been asked.
And you indicated you are getting paid for your work in this case, and you told us your rate's $200, $225 for testimony. Have you tendered any invoices for your work?
Yes, I have.
What was the total?
The total for the first invoice was for 10 hours and a half, and it was approximately $1,800.
And how much additional work hours since then?
20 hours, totaling probably about $2,500 more.
Lastly, you found with the defendant, when you interviewed him over that hour and a half, that not only was he mature, but you gave the opinion that he could handle himself, correct?
Yes, based on his physical stature, his communication, how he was able to answer my questions, he seemed like.
Go ahead.
Okay, keep going. Okay.
Yeah, no, keep
I'm sorry.
talking. He's listening.
All right, okay, he's listening, okay. So based on my observation, he didn't pose a concern of not living in general population, particularly at the jail, the way he's in general population and talking to the officers.
Right.
Yeah.
That wasn't my words, that was your words to me in the deposition, right? That he could handle himself.
Yes.
Okay. Your Honor, I'll tender the witness.
Okay, hold on, any cross, Mr. Hernandez, any cross?
No, thank you.
Any cross, Ms. Toomey? No. And Mr. Petridis? Okay, redirect.
Just a couple follow-up questions, Mr. Bonasco. You said you've never been asked to testify for the state. Are you open to that if somebody were to contact you?
Yes, ma'am.
And backing up to some of the questions you were asked about your kind of employment and assignments over the last, several years, I believe that you said on direct that it's kind of common, this consulting area is somewhat common for somebody who may have your in-depth experience in the jail and prison system. Is that right?
Correct.
Being a retired warden, things like that?
Yes, many of us, because of our national affiliations with national corrections, local jail detentions, a lot of us who retire or have retired once come back, they seek that experience in many cases to get a bit of insight on how the systems work.
Not something that while you're working in that employment, for example, as the warden of a prison, you're not going to come and testify here, are you?
No.
When you were asked about some of your employment, you called them assignments. So I just wanted to clear it up a little bit. Some of the work that you've done, say in Texas and different counties, those are temporary assignments, is that right?
They're all at-will assignments.
So you're not taking a position somewhere and then just quitting?
No.
When you said that in speaking with Mr. Gathright, he was mature for a 20-year-old, was that based upon the conversation you had with him?
My conversation, how he was answering the questions, my years of experience, particularly his age, someone who was 20, was not sharing information, was communicating well, and wasn't disrespectful at all.
You weren't asked to evaluate his decision-making or impulsivity or anything like that, right?
No.
And you were in the jail, I believe, Hillsborough
Yes.
County Jail?
Yes.
Was that in a small interview room?
Yes, it was.
And I presume that you told him that his defense team sent you to see him, is that right?
Yes, I did.
You were asked about some areas of death row and when the inmates can go outside, and you were asked if they were open air, and you said yes, right?
Yes.
The law requires an amount of air and sunshine, is that correct?
Yes, they're required to have sun, also for national accreditation purposes.
When you say open air, does that mean that they're not surrounded by a fence or barbed wire and
No, it's a dog pen, as we call it. They're fenced in entirely. There's not an open fence, but everything's fenced in. You
So
just
no-
have access to sunlight.
not some lovely outdoor recreational area?
No.
And about the air conditioning, I think you clarified it, but just so that we're clear, that when there's no AC or what we know as AC on death row, that's just where the inmates are housed, not the other facilities that they're able to go to, right?
Correct. So for clarification, when you say other, like facilities where lifers are assigned,
Well, just or on death row, if they were to go to a day room, they're going where everybody goes?
yeah, pretty much those units, they're designed with heavy exhaust system, which runs the air more fluidly, more cooler than you would be at a regular prison where there is literally very little flow of air. So it's very hot. The environments are very different.
In the visits that a death row inmate has, Mr. Harmon kind of showed how they're shackled and they have the black box and they're in handcuffs, but those handcuffs are actually removed when they visit with their loved ones, right?
Yes, they are.
And they're allowed a hug and a kiss, I believe.
A hug and an embrace. That's it. Just like the rest of the inmate population.
When someone is sentenced to life without parole, is the goal of the Florida Department of Corrections to rehabilitate that person?
Objection outside the scope.
Overall, go ahead.
No, in my many years of experience as classification officer and supervisor, the standard practice across the industry, those who are serving a term of life, they're not the ones that we are focused on making an investment in. We look at those individuals who have a term of years, so we can provide them programs, betterment, peer-to-peer self-assessment programs, because the goal is to get them in a place so when they get released, they do not reoffend. And with a lifer, we are aware they will never leave the prison system. The only opportunity they will have is they end up at a prison in which maybe we informally as classification officers would keep a list. So if we had a vacant seat in a particular program and they were behaving and following the rules, we would insert them so that seat wouldn't go to waste, but they're still required to work 60 hours a week. They do not get out of work. Versus those with a term of life, less than life, those individuals, if they're going to be getting released, that in many cases, the assignment for them will be education half a day and then work the other half.
So although we've heard that someone serving life without parole is required to work and then may have some opportunity to do programs or mentorships, the ultimate goal is still punishment, correct?
Yes.
No further questions.
Okay, very good. May this witness be excused?
Yes, Your Honor.
Okay, thank you, sir. You're free to go. All right, we're just gonna take a quick 10-minute comfort break and then we'll be back, okay? Thank you.
All right.
Ms. Finkelstein, who's gonna be your next
I
witness?
have two witnesses that should be, and I'm gonna confirm now, should be on Zoom.
Okay.
We're just kind of going based on time, so based on what time it is, we will do Bailey Piotrowski first,
Okay,
and then after that will be Maurice Edwards.
okay.
And I will have them, I think, you should let them in, right? So if they go
Yes,
in a waiting room,
I
you
can
just
let
hang
them
out
in.
there.
Okay, all right, I'll be back in 10 and then we'll get going.